Well, thank you, everybody, for attending. Good afternoon. I am Mark Rozelle, and I serve as Dean of the Schar School of Policy and Government here at George Mason University. Truth on Trial is one of a series of public policy forums put on by the Schar School here at George Mason. The Schar School is one of 10 schools or colleges at George Mason University. We operate both here in Arlington and in Fairfax, Virginia. And we offer a number of degree programs, undergraduate through master's and PhD, in fields of public policy, public administration, political science, international affairs, international security studies, international commerce, and several others. Our programs are very highly ranked, with national security, for example, currently ranked number 3 in the country in the latest U.S. News and World Report rankings. Among our influential institutes and centers that hold events, such as this one today, are the Michael V. Hayden Center on Intelligence Policy and International Security, the Transnational Crime and Corruption Center, the Center for Security Policy Studies, and the newly launched Center for Business Civic Engagement. We have hosted candidate debates and forums, and we have a co-branded poll with the Washington Post.
We've got a terrific panel going right now. Seated to my right in order, we've got Ty Cobb. He served as special counsel to President Donald Trump, widely recognized as one of the premier white-collar Securities and Exchange Commission enforcement and congressional investigation lawyers in the world, as we covered in a previous Truth on Trial event. Ty's gone through periods being hated by members of either party in his careers as he worked with people across the political spectrum. Next to Ty is Stefan Passantino. He's chair of Michael Best's Government and Regulations and Public Policy Practice, in addition to having been a former White House counsel. We're lucky, moving down the aisle, to have Suzanne Rich Folsom. She's an award-winning general counsel and chief compliance officer, having served in leadership roles at U.S. Steel, AIG, and the World Bank. And you've got great experience coming in and cleaning up messes as well.
That's
so
right.
AIG after the crisis.
AIG after the crisis. That's a good point to clarify. Yeah, she's one of the good people who's like, uh-oh, we've got this going. How do we fix it? And Richard Levick, chairman, CEO of Levick Communications. And under his leadership, Levick has set new standards in global communication, brand protection, and you're an advocate for strategic initiatives required by companies in today's perilous business landscape. Lots of news that's happening, touching on the intersection of legal and communications that we'll get into. And the first one, the Mueller Report, is rumored to be issued very soon. I use the word issued lightly because a big question is who's going to get to see it. Obviously, Ty and Stefan, without violating any attorney-client relationships that you've had in your previous work, in the interest of public trust, do you think it should be made as public and available as possible, especially to exonerate people perhaps falsely accused?
I think there should be as much transparency as possible, but it comes in a very strict legal setting. During the Clinton administration, the Hill and the president let the old Independent Counsel Act lapse. They replaced it with a Special Counsel Act in 1999, and that is much more rigorous in terms of the process. The process is pretty simple. The report gets submitted confidentially. A report gets submitted confidentially. It could be 5 pages, it could be 200, but it goes confidentially to the Attorney General. The Attorney General is only obligated to communicate the fact that he's received the report, and if there has been an instance where the Justice Department took or refused to permit the special counsel to take an action that he wanted to take, then the Attorney General has to report that to Congress as well and explain. There's no obligation to make the report public. There is a public interest consideration, but it doesn't generate any rights for either Congress or individuals in court. It can't be litigated because there are no rights created out of that act. So Congress could subpoena it. It would be subject to executive privilege claims should the administration want to do it. My guess is that whatever is presented by the Justice Department will be unsatisfactory to certainly the Democrats, likely the press, and there'll be constant pressure to do it. There's also the possibility of leaks.
If I can maybe add to that, sort of from the perspective of the folks who were working in the White House, and as having been the deputy White House counsel at the time, everyone sort of innately understands this desire for the transparency. Let's put everything out. The public has a right to know. We want to make sure we have all of the facts that are out there. That's all something that there's a great deal of clamor for. But one does also have to look at the fact that the process through which the Mueller probe was able to generate the information that it has is a little different from the normal process, in that a lot of it was very compulsory. Everyone likes reading a Bob Woodward book, or everyone likes reading the books where you're going to get various different people coming forward, giving various anecdotes. Those sources have some degree of control. Am I going to go on the record? Am I going to not talk to this reporter? Am I going to be on some form of background or whatever to put whatever story out there? It doesn't work that way with the special counsel. If you get a phone call from the special counsel's team and says, we would like to talk to you, you are going to go in and talk to that person. Doesn't have to be, as Ty very ably helped all of us, doesn't have to be necessarily compulsory, but you are going to go in and talk, and you are going to answer those questions. If you then have a mechanism whereby you have absolute mandatory compulsory discussion of every last minutia, and then it's all just going to get put out there, whether or not it results in an indictable information or other things, it does actually create an incredible chilling effect to a large extent on people's ability to do these kind of jobs or otherwise control a narrative. So there is this flip side of the government has the ability to obtain massive amounts of information that normally people would think of as either private or not necessarily what you'd want to get out. And you just say, well, we're just going to put all of it out there, regardless of whether it results in anything that's actionable. That's something that there is a natural tension on.
Right, I guess, so where do we put it if it's from all of it out there is one extreme, and I think most reasonable people would agree that, okay, there might be certain things that should be redacted from that. But is it, at a time, the session's called Truth on Trial, lacking transparency with truth so debatable, so fungible these days, isn't it in the national interest to try and get as much out as possible? And Suzanne and Richard, I'll let you guys weigh in on this in a moment.
But, well, there's some difficulty with that, which is, I've read recently people saying, well, you can go the Leon Jaworski route or the Ken Starr route and, have a short report or a, multi-volume treatise. But the reality is there are legal considerations, and there are two statutes that, in particular, that directly affect what can be released. One involves grand jury secrecy. One involves, the discretion of the Attorney General in connection with however he wants to summarize or put something out. Would he do the report with redactions? I doubt that. I think it'd be more likely to be a Justice Department summary of the findings if he did that. But you just don't know, and so and this gets into the issue of people complaining about Starr and the ability to put that report out there and all the passion that was ginned up at that stage of the game that forced the new statute, which was designed to pull back on that, and that's the
because no granular detail was
restriction.
Left uncovered in the Starr report.
Right, and Bob has done. Bob Mueller has done, effective job, I believe, in the indictments and sentencing memos of telling the story that he has. So it's not necessarily that there aren't a lot of facts already out there. It's just on everybody's collusion meter, they want to see where things land, and I'm not sure. I'm not sure that everybody's going to be satisfied on that.
Right, yeah, it sounds like it'll be challenging. Suzanne, Richard, do you want to weigh in with your perspective?
Well, thank you, Suzanne. I can't tell you how much I appreciate it. I don't know if
Pass to
you
you,
could
Richard.
see, and for those people who are just watching on television or on the webcast, they can see Suzanne's hand like, please, go ahead. Disagree with these two presidential counsel and go at it, have fun. And I can't wait to see who's paying for dinner later. But, a couple of thoughts. One, Doug, you make the point that, and I'm not, as a non-practicing lawyer, I'm certainly not going to take issue with anything that the President's counsel have identified here, both because I'm incapable and also for no particularly good reason. But we assume that transparency, by definition, isn't necessarily better. It's not. I think, one, if we look at Ken Starr's motivation, it was legal. He was so shocked by the behavior of the president that he thought the country would be shocked, and that alone would be enough to tip the United States Congress to impeachment. The question I think we have to ask ourselves, which is, if you think transparency is good now, will it be good when there's a Democrat who's president, who will be investigated? There is no question. If anything has gotten extraordinary endorsement, is the use of special counsel, which can go in any direction they so choose. And just be aware, it's got to be good. What's good for the goose has to be good for the gander. Part of my concern already we're seeing on the House side, and I will say I think we have 3 Republicans and the lone Democrat here, but I will say that it concerns me if the House, now in Democratic hands, is already thinking about restricting rights to counsel for witnesses at hearings. That may work when you're in the majority, but I'm not sure how well it's going to work when you're not. And I would take that down, which is to a personal level. If we're going to exist in this intoxication of too much information environment, where we're all rushing to conclusions before we have information, we have to be able to look in the mirror and appreciate that we have the right to change our minds or to view things differently, and we can't be outcome determinative. We don't like Donald Trump, therefore the rules of transparency apply. Oh, but if we do like the president, not so sure how I feel about transparency.
Suzanne?
I think from a corporate America perspective, people would just like this to be done, whichever way, and because corporations are concerned about creating shareholder value. And at the end of the day, it's interesting when you leave the Beltway, and for me, having spent so much of my career here and then having gone outside to work in corporations, it's amazing how little attention the rest of America pays to issues going on in Washington. So I think people would just like a resolution one way or the other.
Yeah, unfortunately, it sounds like it's not going to be a clean resolution, and this is something that's
Right.
going to go on going. Now the battle will turn to what's the information we can get and go there. We could bog down the whole conversation with this, and not to diminish its importance, I want to just get into another area that's interesting from a law and public relations perspective that we'll be getting into with our next group, and this is sort of a Doug theory perspective. Tell me if I'm right or wrong, but I see on TV Michael Avenatti, Rudy Giuliani, Lanny Davis. They don't seem to me to be acting as attorneys in that role, but as public relations spokespeople. And this also happens within corporations. So what are the implications of, quote, lawyers becoming PR spokespeople? And does that have an issue with, does that mess with attorney-client privilege? What can they say? What should they say? What shouldn't they? Where do they sort of draw that line?
There are very real dangers when you do that, as Lanny Davis found out recently when he misled the country with regard to certain facts that Cohen would allegedly testify to, and he had to walk it back. Clearly didn't have his client's authority to say it. Turned out not to be true. When he makes statements like that, he's acting as an agent, so it could be used against Cohen. I think that you see lawyers get out, as was said well in the earlier panel, that the day of letting the story come to you is over. You got to get out and manage the story. You've got to, and you need to do it very professionally. Try to limit the facts, make it clear what the process is, and be accurate. And one of the most important things, as the governor said, and as is highlighted by the Virginia situation, is you have to master the facts immediately before you talk. Because putting out a palliative, that's not going to help you. You need to be able to make a forceful statement that's factual and will stand up under scrutiny. You can't have a changing story or you bury yourself.
I think it's helpful to add, too, that especially for the purpose of this panel, as a lawyer, the natural instinct as a lawyer is, as Ty was just saying, let's go underground, nobody says anything, counsel your clients, you're not going to talk, we're not going to put anything out. That's the lawyer's natural instinct. When you're dealing with a hyper-intense media environment where there are numerous angles and there are numerous different agendas out there from media, from opponents, from watchdog groups, from whoever, all of whom are going to pounce on anything and try to frame a narrative in a way that does not necessarily suit your client's advantage at all, you do not have the ability to take the normal legal instinct and say, we're going to shut down. So as a lawyer, you have to be in that environment, or that intensity that we had, which we in the White House counsel's office called a Tuesday, usually. That was sort of every day the way that it was. But there is a key concept to understand. As a lawyer, there are very important other principles. Attorney-client privilege, phenomenally important principle, subject to waiver under the right circumstances. Also, as I think in some of the circumstances we've talked about before, as a lawyer, you must engage, but you owe a fiduciary duty to the interests of your client. And it's very, very, very easy for lawyers who think that they're out promoting the interests of their client to sometimes lose sight in the fight, the rough and tumble of the fight, of the fact I have one job, and that is under no circumstances am I to do harm to my client, even if it is in my own personal interest to go down a certain path. And so it is very, very perilous for lawyers to try to become amateur PR professionals under those kinds of circumstances, but you also don't have the luxury of doing nothing.
Well, and another very important thing that I put into play in my private practice when I represented controversial clients or boards and crises, you want to have Richard Levick on speed dial.
Mm-hmm. Yeah, no, and that's an important point we were discussing earlier about the connectivity between the PR representation and the legal so they can fully understand the nuances. That's important. So I guess bad news from the earlier panel that all the PR people should renounce their political clients, but now good news that the company should still call you in times of crisis, so we're trying to balance it out. Suzanne, you had said some interesting things when I was speaking with you earlier about what are some of the legal issues that brands, nonprofits will be facing coming up. Two you pointed out of special importance are cybersecurity and privacy issues. You want to talk like how do brands sort of protect themselves from what might be coming down the pike, and Richard, you as well, and then we'll get some issues inside companies and how to navigate and manage them before we get to our final media and communications panel.
Before I touch on that, I just wanted to say that I think it's really important that within the corporation that legal be involved from the beginning. And I think that many corporations that have not found themselves in crisis haven't had legal involved. So when the crisis hits, they don't automatically think to go to legal. So you'd be amazed at how many Fortune 500 companies don't have crisis communications plans, or if they do have one, it's really very basic. So I think it's really important that legal be involved. I think the other point is that with respect to communications, where do they report within the corporation? And that's really important. I personally don't think HR, which is where most corporate communications teams report, is necessarily the best, especially if a crisis hits. So if they don't report to the CEO, they should report to legal, because so many of the issues that you're dealing with have legal ramifications. So you've had a cyber attack. How do you handle that? You're going to need legal involved. You know, there's privacy issues with whatever was exfiltrated. You know, you need to have legal involved. And in those initial couple of hours, if legal is not involved, there can be some really serious mistakes made by the corporation that could cause additional legal trouble down the road beyond whatever the initial breach or problem was. So for cyber and privacy, every corporation, no matter who you are, your company has something of value. So somebody may think you're a steel company. You know, what do you have of value that everybody has something of value that's going to be exfiltrated at some point or has. So legal needs to be involved there.
Yeah, I always tell clients that the first 48 hours are essential because that is where 90% of the mistakes in case management happen. And Suzanne, I know from her compliance background, you know, has seen this, that, you know, there will be 20 conversations that don't involve legal, all of which are subject to, you know, a lack of privilege. and people would have to testify about it. So getting legal in immediately to preserve the privilege and to ensure that nobody screws anything up and the documents are preserved and that the company acts honorably. Whatever's happened in the past, that they act honorably from that, the first sign of an investigation forward.
Richard, also?
I just want to say one other thing, and I think it's also important that before the crisis happens, that you're running your red team drills. I mean, people are doing things with respect to safety. They should also be doing it with respect to other areas that could cause reputational damage, to the corporation. You should be running ahead of time. Richard and Ty, I've had the good fortune in more than one company in crisis to work with and have their outside counsel. AIG was one. We had the main crisis going on, but we were red teaming the entire time all other types of crisis situations that we could have, and I think 9 out of 10 of them unfortunately ended up happening, but we were prepared for them in the midst of the bigger crisis.
I want to add also, though, that the corollary to the notion that, okay, all communicators must work with counsel, very valid, but the flip to that is counsel also needs to understand when you are working with the communications team, you cannot tell the communications team to run dark. You cannot. If you don't actually set the narrative in those first 48 hours, that is set in the mind of the public. And it is extraordinarily difficult to undo that initial presumption. And so I would say it's just as incumbent to make sure that counsel understands you are going to be putting a narrative out there, whether you like it or not. It's got to be accurate. It's got to make sure that you don't put anything false out there. But you cannot do the normal legal instinct and just say, we're just going to let this thing sit and we'll see how this thing plays out.
Right, and Richard, you to comment, and then we'll get to a couple more quick questions from each of you to move on to the next panel. We started a few minutes late, so we'll be extending the time for all stations down the line carrying the programming. They should be aware, Richard.
So thank you. The Heidi Bowl revisited. So a few thoughts here. One, just to touch on the point that everyone is making in terms of the teamwork. When we were doing crisis work 2 decades ago, very few people said they do crisis work. Now every PR firm that's ever handled a slip and fall says they do crisis, and there are a number of great firms here that are going to be on the next panel. We work very closely, with the folks from Edelman and some of the other great firms. But there are lots of firms all over the country who don't have their experience and don't haven't handled the kinds of matters. When Suzanne is talking about the first 48 hours, most matters are not single jurisdiction. They're multi-jurisdictional. And so now you've got a problem where, like with TARP, it's per se illegal in 2 countries, in Singapore and Mexico, but it's of course legal in the United States. How are you going to handle it from a legal point of view? How are you going to handle it from a communications point of view? Because someone's not going to be happy. And so it's not just that it's rote that you're required to have the relationship. You have to have a trusted and close relationship now. And because things move so quickly, you have to be proactive. You have to know and trust each other. Next, to the question you asked about Lanny and Rudy and Michael Avenatti. Look, we've represented over 300 law firms around the world in high-profile matters, and I've known Lanny for 30 or 35 years. I still can't figure out what he's doing. In the morning he's PR, in the afternoon he's lawyer. From a privilege point of view, I'm always confused by that. And for Michael Avenatti, quite frankly, when he announces during Stormy Daniels and in between the Kavanaugh hearings that he's thinking about running for president, I'm really concerned about the position that the clients have with him, because they sound like they're stepping stones as opposed to the most important people in the room. And then finally, I think we are in an age of mercantile activism. Suzanne talked a little bit about it, but corporations historically have wanted to avoid being in the limelight by being political. There have always been a few exceptions, but almost always. We're past that time. We now, Airbnb is going to weigh in on Brexit, and WeWork is going to weigh in on vegetarianism, not, by the way, on SoftBank. How fascinating, right after the Jamal Khashoggi assassination, since 70% of WeWork's money comes from Saudi Arabia. But fascinating that they would weigh in on that and therefore be unable to weigh in once again. And so the list goes on and on. I think Nike's position and being so political is very, very smart, but very scientific. They knew exactly where their dollars were coming from. And so it was very, very thoughtful. But I think if companies think that they're going to be able to avoid being political, that is no longer a viable option. It's no longer just your CSR or what you're selling or your brand. It's where you're communicating. It's who's in your advertisements. It's whether or not you pull your ads fast enough from some anchor who has offended another group. So you have to be extremely thoughtful. And again, that gets us back to the requirement of teams. And the most challenging issue for us now, particularly for companies that are AIG size, how are we going to exist in a post-silo world? HR, GR, PR, for 70 years they've existed fine in their own silos. We are post-silo. How do you create integrated teams that know and trust each other? I don't know the answer to that. I just know it's necessary.
Great, and because Richard mentioned the New York Jets and the Heidi Bowl piece, I will bring up, C-suite bad behavior for one final thought with Robert Kraft as a recent example, Elon Musk tweeting out questionably valid information to move the market. How do PR folks, and just if you can give a quick thought on that to wrap up and we'll move on to the next panel after, how do PR folks, bridge the gap and prepare for that? Is it about doing better due diligence? Me Too fits under there. How do you get the better information to protect your brand?
Well, it clearly starts before it happens. And so from a compliance standpoint, and that falls with legal, that falls with PR, that falls on all these, there is no substitute for making sure that folks understand what the rules are in advance. You've done some degree of training, you've really reinforced those notions. And then you're sort of there. And once it happens, you better hope that the systems in place can start moving effectively.
No, I agree 100% with that. I mean, you can't really prepare for something like the Robert Kraft thing. You need to go straight to well-trained people and hope they do their best work, because it's not something that you plan for. But the teamwork is essential. People have been trying to get this formula right for 2 decades. People move too fast sometimes. People move too slow. That's why you have to have the red team drills. Figure that out. And facts rule. Facts rule. I mean, so take the Justice Smollett event. People who moved in too fast and were too judgmental. Obviously have some egg on their face. It's understandable. It's not a reason to crucify anybody, but getting your facts right and maybe waiting a day for the police to
and we'll get to that with the news cycle with the next group.
And the same thing on a Me Too, a Les Moonves type thing. You have to. It's something where people need to understand. Even if you don't have an answer, you're taking it seriously.
Right. And Suzanne, maybe the issue of making it easier for whistleblowers to come forward within organizations to sort of nip that kind of behavior in the bud, as you were mentioning earlier, maybe can play a role. What's your last piece of advice?
Sure. Well, I think that the role of the legal department in corporations is changing, and it's changed in the past 10 years, and it's expanded. But more importantly, I think the type of people that you hire into that legal department, you need to have lawyers that have had other experiences beyond just being a lawyer, that have had compliance experiences, government, have worked in different situations. The model before of going to college, law school, maybe a firm and into the corporation. And that becomes really important because a point that was made earlier by both Ty and Stefan, that you need lawyers that aren't just going to shut things down.
Right.
But they need to have had those experiences to be able to inform their ability to work better with the communications people. So yes, you need to have the right policies for whistleblowers, but I think most big corporations out there have those policies. It's a question of whether the corporation really practices what it preaches with the documents, and many still do not.
Richard?
We have now, for the first time in our lives, we are existing in a democracy, not a republic, a democracy. Every bit as what Thomas Jefferson and others would argue Andrew Jackson envisioned, not what John Adams envisioned, where we didn't have direct election of senators. We certainly didn't have the kind of impact that we had. I think the tragic and larger question for us right now is, how capable are we each of us, of existing in a democracy. We are so willing to be so judgmental so quickly. You know, as someone who, as a 6-year-old, remembers listening to Martin Luther King and hear white critics on radio, and as a 6-year-old being offended and impacted, and then a couple years later, after his assassination, hearing those same white people talk about, oh, what a great leader he was. Like, now that he's a martyr, he's safe, and we can say nice things. And as an 8-year-old being offended by that. And yet to see the rush to judgment now on Jussie Smollett, to see a Me Too movement in which, and I know I'm saying all these unpopular things here, in which my master's thesis was on pay equity and the history of the women's rights movement. And yet sometimes seeing that movement being used for power and not justice. Or, as I remarked earlier about how the Democrats are already trying to change some of the rules, and so it's about power and not righteousness. It's really, really hard, as Winston Churchill said, that democracy is the least form of government except for all the others. And I think our jobs, you know, all of our jobs, it's not about spin. Our jobs is about a race to the truth. How do we get truth out there? And I think we need to exist in a society where just because we have access to Facebook and other social media and that we can weigh in instantly without the facts doesn't mean that we should. And when we look at Facebook, we're concerned enough that they may have inappropriately allowed the Russians to be involved in our elections, and India and the Philippines, and in Myanmar, for God's sakes, where it was used for the murder of 46,000 people, in excess of 46,000 people. These are really, really serious issues, which none of us should leave here feeling great that we have the answer because we're in power, but because we have to figure out how to deal with this, and we need to remember this, and you know, the governor's not here anymore, this is the great experiment. Democracy is a great experiment, and we have to earn it every day.